I found out my family had been funding the entire Meadowbrook Hills Homeowners Association for 37 years when a contractor showed up at my door with a confused look on his face and a stack of property maps that would change everything. My name is Marcus Donovan, and I had just inherited my late grandfather's property in Scottsdale, Arizona, a sprawling 5-acre plot on the edge of what used to be undeveloped desert land. The house itself was a modest ranch-style home built in the early 70s, but the land was what made it special. My grandfather, Robert Donovan, had purchased the property back in 1987 for what seemed like pennies compared to today's real estate prices. He lived there until he passed away at 92, just 6 months before I arrived to claim my inheritance. The contractor's name was Miguel, and he was holding a survey report that his company had prepared for a potential buyer interested in the adjacent lot. "Mr. Donovan," he said, scratching his head beneath his hard hat, "I think there's been a mistake with the property lines in this neighborhood. A big mistake." I invited him inside, offering him a glass of water as we sat at the kitchen table. The Arizona heat was relentless that August afternoon, and the air conditioning hummed steadily in the background. Miguel spread out several maps across the table, some yellowed with age, others freshly printed with crisp lines and digital precision. "See this?" He pointed to a highlighted section on one of the newer maps. "This is your property line according to the original deed from 1987. And this," he moved his finger to a different map, "is what the HOA has been using as the neighborhood boundary since 1988. I leaned in closer, trying to make sense of the overlapping lines and measurements. "I'm not following. What's the problem?" Miguel pulled out another document, this one showing the layout of the entire Meadowbrook Hills subdivision. "The problem, sir, is that the HOA community center, the swimming pool, the tennis courts, the playground, and about half of the main parking lot are all built on your land. Well, your grandfather's land. Now your land." The words hung in the air like a thunderclap. I stared at the maps, then back at Miguel, waiting for him to crack a smile and admit it was some kind of joke. He didn't. "That's impossible," I finally said. "The HOA has been here for decades. Someone would have noticed." Miguel shrugged. "I'm just showing you what the survey revealed." We did 3 separate measurements to be sure. Your property extends about 200 feet further east than what the HOA thinks is the boundary. There's a fence line that everyone assumed was the property division, but according to the original land patents and your grandfather's deed, that fence is entirely on your land. I spent the rest of that evening poring over the documents Miguel had left with me. I pulled out the deed my grandfather's attorney had given me during the estate settlement, along with every other piece of paperwork related to the property. The more I read, the more Miguel's assessment seemed accurate. My grandfather's property was significantly larger than I had realized, and more importantly, it included land that the Meadowbrook Hills HOA had been treating as their own for nearly 4 decades. The next morning, I called the law office that had handled my grandfather's estate. The attorney, a sharp woman named Patricia who specialized in property law, asked me to bring in all the documents. When I spread them across her conference room table 3 days later, her eyes widened with the same surprise I had felt. "Marcus, this is quite a situation," she said, adjusting her reading glasses as she examined the survey report. "If these measurements are correct, and I have no reason to doubt a licensed surveyor, then your grandfather's estate, and now you have a legitimate claim to this land." "But how did this happen?" I asked. "Wouldn't the HOA have checked property lines before building?" Patricia leaned back in her chair, tapping a pen against her notepad. "You would think so, but mistakes like this happen more often than you'd imagine." Sometimes it's an error in the original subdivision plat. Sometimes it's an old fence line that everyone assumes is the legal boundary. Sometimes developers, or HOAs, simply encroach on adjacent property and hope no one notices or cares enough to challenge it. My grandfather lived right next to all this for decades. Why wouldn't he have said something? That's a good question. Did your grandfather ever have any disputes with the HOA? I thought back to the stories my mother had told me about Grandpa Robert. He had always been a quiet man, someone who valued peace over confrontation. Not that I know of. He mostly kept to himself. He was never actually part of the HOA because his property predated the subdivision. Patricia nodded. That makes sense. The subdivision was developed in 1988, a year after he purchased his land. He was grandfathered in, so to speak, with no obligation to join the HOA. But here's what I find interesting. She pulled out a folder from her briefcase and opened it to reveal several financial documents. I did some research after you called. The Meadowbrook Hills HOA has been collecting dues from 247 homes since 1988. Their annual dues currently run about $1,200 per household, but they've increased over time. In the early years, it was around $600 annually. Okay, I said, not quite seeing where she was going. Those dues pay for the maintenance and upkeep of the community amenities, the pool, the tennis courts, the landscaping, the community center. All the things that are apparently built on your land. The realization hit me like a freight train. They've been profiting from my family's land this whole time. Exactly. They've collected millions of dollars in dues over 37 years, all while using your property as the foundation for their amenities. Without your land, they would have had to build those facilities elsewhere, purchase additional property, or perhaps not build them at all. I sat back in my chair, feeling a mixture of anger and disbelief. So what do we do? Patricia smiled, the kind of smile that told me she was ready for a fight. We start by having an independent survey company verify these findings. Then we send a formal notice to the HOA board informing them of the boundary dispute and demanding they cease operations on your property. We'll need to research whether there's any claim of adverse possession they could make. Adverse possession. It's a legal doctrine where someone can claim ownership of land they've been using openly and notoriously for a certain period, typically ranging from 5 to 20 years depending on the state. In Arizona, it's 10 years under certain conditions. However, there are specific requirements that must be met, and given that your grandfather was alive and living on the adjacent property until recently, it's unlikely they can claim it. Over the next 3 weeks, Patricia arranged for 2 additional survey companies to assess the property boundaries. Both confirmed Miguel's findings. The Meadowbrook Hills HOA had indeed built their primary amenities on land that belonged to me. Armed with this evidence, Patricia drafted a formal letter to the HOA board. The response came faster than I expected. 2 days after Patricia sent the letter, I received a phone call from a woman who introduced herself as Brenda Morrison, president of the Meadowbrook Hills HOA board. Mr. Donovan, I'm calling about this absolutely ridiculous letter your attorney sent us, she said, her voice dripping with condescension. I don't know what kind of scam you're trying to pull, but the HOA has owned that land for decades. We have the documents to prove it. I took a deep breath, reminding myself to stay calm. Mrs. Morrison, I'm not trying to scam anyone. I have 3 independent surveys that all confirm the same thing. The amenities are on my property. That's absurd, she snapped. We've had property assessments done over the years. Someone would have noticed if there was a boundary issue. Then, I'd be happy to meet with you and the board to review the evidence. My attorney will be present as well. There was a long pause on the other end of the line. Fine. We'll have an emergency board meeting this Saturday at 10 in the morning. You can present your so-called evidence then. She hung up without saying goodbye. I immediately called Patricia to let her know about the meeting. Saturday morning arrived with the kind of heat that makes you reconsider living in Arizona. I dressed in business casual attire and met Patricia at her office. We drove together to the Meadowbrook Hills Community Center, the very building that sat on my land. The irony wasn't lost on me. The community center was a nice facility, I had to admit. It had a large meeting room with comfortable chairs, a commercial kitchen, and floor-to-ceiling windows that looked out onto the swimming pool and tennis courts. About a dozen people were already seated when we arrived, including 5 board members sitting at a long table at the front of the room. Brenda Morrison sat in the center, a woman in her late 50s with perfectly styled blonde hair and an expression that could curdle milk. "Mr. Donovan," she said icily as we entered, "and you must be the attorney. Please have a seat." We sat in the front row of the audience section. I noticed several residents had also shown up, probably curious about what was going on. Brenda called the meeting to order and immediately addressed the issue at hand. "We're here today because Mr. Donovan has made some outrageous claims about our property. Marcus, why don't you explain to everyone what you think is happening?" Patricia stood up before I could respond. "Mrs. Morrison, I'm Patricia Chen, Mr. Donovan's attorney. I'd like to present the evidence we've gathered if that's acceptable." Brenda waved her hand dismissively. "Please go ahead. I'm sure we could all use a good laugh." Patricia remained professional, setting up her laptop and connecting it to the projector in the room. She displayed the first survey report, explaining the methodology and findings in clear, precise terms. Then she showed the second survey and the third. She overlaid the original deed from 1987 onto a current map of the subdivision, demonstrating how the property lines had been misidentified or ignored when the HOA was formed. The room grew quieter as she presented each piece of evidence. I watched the board members' faces shift from smugness to concern to what looked like barely concealed panic. Brenda, however, maintained her hostile expression. "This is all very interesting," Brenda said when Patricia finished, "but I find it hard to believe that this supposed error went unnoticed for 37 years. Clearly, these surveys are wrong or you're misreading the original documents." Patricia smiled politely. "Mrs. Morrison, these surveys were conducted by 3 separate licensed companies with excellent reputations. They all reached the same conclusion independently. Furthermore, I have the original land patent from the Bureau of Land Management, the deed transfer documents from 1987, and the subdivision plat from 1988. Would you like to review them?" "I would," said one of the other board members, a balding man in his 60s named Gerald. Brenda shot him an angry look, but he stood up and walked over to examine the documents Patricia had brought. For the next 30 minutes, Gerald and 2 other board members reviewed everything while Brenda fumed silently in her chair. The residents in attendance began whispering among themselves, and I could feel the tension in the room escalating. Finally, Gerald returned to his seat and leaned over to whisper something to Brenda. Her face turned red and she slammed her hand on the table. "This is unacceptable," she shouted. "Even if there is some technicality with the property lines, we've been maintaining and improving this land for decades. We have rights." Patricia remained calm. "Mrs. Morrison, I understand this is upsetting, but the law is clear. My client owns this land. The HOA has been operating on private property without permission or compensation. We'll fight this in court." Brenda said through gritted teeth. "We'll claim adverse possession. We'll prove that we have rightful ownership through continuous use." "You're welcome to try," Patricia replied, "but I should warn you that adverse possession requires specific conditions to be met under Arizona law. The use must be hostile, actual, open and notorious, exclusive, and continuous for at least 10 years. Furthermore, the property owner must be aware of the encroachment or have reasonable means to know about it. Given that Mr. Donovan's grandfather lived on the adjacent property until 6 months ago, and given that the HOA deliberately established these amenities and has actively maintained boundaries that exclude his property, you'll have a difficult time proving your case." Brenda stood up abruptly. "This meeting is over. The board will consult with our attorney and respond in due time." As everyone began to leave, several residents approached me with questions. Some were sympathetic, others seemed angry, though I wasn't sure if their anger was directed at me or the board. One woman, probably in her 70s, touched my arm gently. "Your grandfather was a good man," she said. "He used to let my grandchildren retrieve their toys when they'd bounce over into his yard. I'm sorry you're caught up in this mess." I thanked her and left with Patricia. As we walked to her car, she turned to me with a serious expression. "They're going to fight this, Marcus. Brenda Morrison doesn't strike me as someone who admits defeat easily. You need to be prepared for a long battle." "What do you think they'll do?" "They'll hire a lawyer, probably argue adverse possession or try to find some error in the surveys or deed. They might claim your grandfather gave implicit permission for them to use the land. They might even try to claim the HOA's establishment created some kind of easement or prescriptive right." "Can they win?" Patricia shook her head. "Not likely, but they can make this expensive and time-consuming. My advice is to be patient and let them waste their money on a losing case. Eventually, they'll have to negotiate." I spent the next few weeks trying to live normally while waiting for the HOA's response. I had moved into my grandfather's house, using the inheritance he left me to cover basic expenses while I figured out what to do with the property long-term. The house needed some updates, but it was comfortable and the land was beautiful, especially in the early morning when the desert came alive with wildlife. A month after the board meeting, Patricia called me with news. "The HOA has responded through their attorney. They're denying your claim and arguing that the surveys are incorrect. They're also claiming that even if the surveys are accurate, they have a prescriptive easement based on decades of continuous use." "What does that mean?" A prescriptive easement is similar to adverse possession, but instead of claiming ownership, they're claiming a legal right to use the property for specific purposes. To establish a prescriptive easement in Arizona, they need to prove the use was open, notorious, continuous, and adverse under claim of right for at least 10 years. Can they prove that? Possibly, but there are defenses. If your grandfather gave them permission to use the land, even implicitly, then the use wasn't adverse. If he objected at any point, that would break the continuity. We need to find out if there's any documentation of your grandfather's relationship with the HOA. I spent the next week going through every box, file, and drawer in my grandfather's house. I found old photographs, military records from his service in Korea, love letters between him and my grandmother, but nothing about the HOA. Then, in a filing cabinet in his garage workshop, I discovered a folder labeled simply HOA. Inside were copies of letters, meeting minutes, and handwritten notes spanning from 1988 to 2003. My hands trembled as I read through them. The story they told was infuriating. In 1988, when the Meadowbrook Hills subdivision was being developed, The developer had approached my grandfather about purchasing a portion of his land for the community amenities. My grandfather had declined, not wanting to sell any part of his property. The developer had then proceeded to survey the land for the subdivision, and according to my grandfather's notes, had deliberately misrepresented the boundary lines. My grandfather had noticed the error shortly after construction began on the community center. He had written multiple letters to the developer, the HOA board, and even the city planning department. The responses ranged from dismissive to hostile. The developer claimed the surveys were correct. The HOA board, in a letter signed by the original president, stated that the matter has been thoroughly investigated and your claims are without merit. In 1990, my grandfather had consulted with an attorney about the issue. According to a letter from that attorney, pursuing the matter would require expensive litigation with no guarantee of success, especially since the community center was already built. The attorney advised that my grandfather could continue to assert his property rights and ensure the encroachment didn't ripen into an easement by periodically objecting in writing. My grandfather had done exactly that. Every few years, he wrote to the HOA board asserting his ownership of the land and objecting to their use of it. The last letter was dated 2003, addressed to Brenda Morrison, who had apparently been involved with the HOA for over 2 decades. In that letter, my grandfather wrote, "This is my final written notice that you are trespassing on my property. I am an elderly man who lacks the resources to fight a protracted legal battle, but I want it on record that I have never given permission for your use of my land, and I object to your continued encroachment. My heirs will deal with this matter after I'm gone." I immediately scanned every document and sent them to Patricia. She called me within an hour of receiving them. "Marcus, this is exactly what we needed. Your grandfather's consistent objections destroy any claim of adverse possession or prescriptive easement. He never gave permission, he actively opposed their use, and he documented everything. The HOA knew they were on his property and chose to ignore it. So what happens now? Now we go on the offensive. I'm going to file a lawsuit for trespass, unjust enrichment, and conversion. We're going to demand compensation for every year the HOA has used your family's land for their profit." The lawsuit was filed in October of 2025. The complaint laid out the facts methodically. The surveys proving ownership, my grandfather's objections, the HOA's refusal to acknowledge the boundary issue, and most importantly, the money they had collected. Patricia calculated that the HOA had collected approximately $22.4 million in dues since 1988, with a significant portion of that justified by the existence of the amenities on my land. The HOA's attorney filed a motion to dismiss, arguing that the statute of limitations had expired on any claims. Patricia countered that the continuing trespass and unjust enrichment meant the statute of limitations reset with each year of illegal use. The judge denied the motion to dismiss, allowing the case to proceed to discovery. Discovery was where things got really interesting. Patricia subpoenaed all of the HOA's financial records, board meeting minutes, and correspondence dating back to 1988. What emerged was a pattern of willful ignorance and, in some cases, deliberate deception. The original developer had indeed misrepresented the property boundaries when creating the subdivision plat. Internal documents showed that a surveyor had flagged potential issues with the eastern boundary, but the developer had dismissed the concerns and proceeded with construction. When my grandfather had raised objections, the developer and early HOA board had made a calculated decision to ignore him, betting that he wouldn't or couldn't afford to sue. More damningly, There were minutes from a 1992 board meeting where members discussed my grandfather's letter. One board member had suggested they negotiate with him to purchase the land or establish a formal easement. Brenda Morrison, who was the HOA secretary at the time, had argued against it. According to the minutes, she said, "If we acknowledge his claim, we validate his position. Better to maintain that he's wrong and wait him out. He's already in his 60s. Eventually, this problem will solve itself." That quote would come back to haunt her. The depositions began in January 2026. I sat in on Brenda Morrison's deposition, and it was a masterclass in watching someone dig their own grave. Patricia was professional but relentless, taking Brenda through decades of decisions and correspondence. "Mrs. Morrison, you were secretary of the HOA board in 1992, correct?" "Yes," Brenda answered stiffly. "And you attended the board meeting on March 15, 1992. If the minutes say I was there, then I was there." "Do you recall discussing Robert Donovan's letter about the property boundary?" Vaguely. "It was over 30 years ago." Patricia slid a copy of the meeting minutes across the table. "These minutes quote you as saying, and I'm reading directly, if we acknowledge his claim, we validate his position. Better to maintain that he's wrong and wait him out. He's already in his 60s. Eventually, this problem will solve itself. You recall saying that?" Brenda's face flushed red. "I may have said something like that, but you're taking it out of context." "What context would make that statement appropriate, Mrs. Morrison? We genuinely believed our surveys were correct." "I was simply suggesting we not give credence to a claim we thought was false." "But you also said, eventually, this problem will solve itself. What did you mean by that?" "I meant that maybe he would eventually see that he was wrong. Or that he would die and you could continue using the land without objection." Brenda's attorney objected, but the damage was done. The deposition continued for 6 hours, and by the end, Patricia had established a clear pattern. The HOA board had known about the boundary dispute, had received multiple objections from my grandfather, and had deliberately chosen to ignore the issue rather than address it. Over the next 3 months, Patricia deposed other former and current board members, the original developer, who was now retired and living in Florida, and several long-time residents. The picture that emerged was of an HOA that had built its community amenities on land it didn't own, ignored the rightful owner's objections, and profited from the situation for nearly 4 decades. In April, the HOA's attorney reached out to discuss settlement. Patricia and I met with them in a conference room at a neutral location. Brenda was there, along with 2 other current board members and their attorney, a tired-looking man named Richard, who clearly knew his clients didn't have a strong case. "Let's cut to the chase," Richard said. "What do you want?" Patricia opened her briefcase and pulled out a detailed settlement proposal. "Mr. Donovan is willing to resolve this matter in one of 2 ways. Option 1. The HOA can purchase the portion of land containing the amenities for fair market value, which we've appraised at $1.8 million based on comparable commercial property in Scottsdale. Additionally, they will pay Mr. Donovan for the past use of his land." "How much for past use?" Richard asked, though his tone suggested he knew he wouldn't like the answer. $4.2 million, representing a fair rental value for commercial community amenities over 37 years, plus interest. Brenda gasped. $6 million. That's insane. We don't have that kind of money. Patricia continued calmly. Option 2. Mr. Donovan retains ownership of the land. The HOA will remove all structures and improvements from his property within 6 months and pay him $5.8 million for past use, which is slightly reduced since he's keeping the land. Both options are outrageous. Brenda sputtered. "If we pay that, we'll have to levy a special assessment of over $20,000 per household. The homeowners will riot." "Then perhaps you should have addressed this issue when Robert Donovan first raised it in 1988, Patricia replied. "Or in 1990, 1995, 2000, or 2003. You had multiple opportunities to resolve this properly. Your board chose to gamble that the problem would disappear. It didn't." Richard cleared his throat. "Let us discuss this with our board and the membership. We'll need time to review our options." "You have 2 weeks," Patricia said. "After that, we'll see you in court." The next 2 weeks were chaotic. Word of the settlement proposal leaked to the HOA membership, and suddenly my phone was ringing constantly. Some residents called to express sympathy and understanding. Others left angry voicemails accusing me of trying to destroy their community. Someone started a Facebook group called Save Meadowbrook Hills that quickly gathered over 1,000 members, many arguing that I should just donate the land to the HOA and forget the whole thing. I had to make my social media accounts private after I started receiving threats. Nothing explicitly violent, but enough angry messages that I felt uncomfortable. Patricia assured me this was normal in high-stakes property disputes, but it didn't make it easier. The HOA held a special membership meeting to discuss the situation. I wasn't invited, but several sympathetic residents filled me in on what happened. Brenda had presented the situation in the most favorable light possible for the board, claiming they were victims of an old surveying error, and that I was being unreasonably greedy. She proposed fighting the case all the way to trial, confident they would win. Other residents, particularly those who had been in the neighborhood since the early days, weren't buying it. One man stood up and read portions of my grandfather's letters aloud, asking why the board had ignored repeated objections for decades. Another woman pointed out that the board had put the entire community at financial risk by not addressing the issue earlier. The meeting devolved into shouting matches and accusations. By the end, the membership had voted to remove Brenda and 2 other board members from their positions, replacing them with residents who pledged to settle the matter quickly and minimize the financial damage. The new board president, a retired accountant named Thomas, called me directly the next day. "Mr. Donovan, my name is Thomas Chen. I was just elected to the board and I want to apologize for how you and your grandfather were treated. What happened was wrong and I want to make it right." His sincerity was refreshing after weeks of hostility. "I appreciate that, Thomas. I'm not trying to destroy the community. I just want fair compensation for what happened. I understand. The board has reviewed your settlement proposals, and frankly, while they're steep, they're fair given the circumstances. The problem is we don't have $6 million sitting in our reserves. We have about $400,000 in our accounts. What are you proposing? Would you be willing to accept a payment plan? We could levy a special assessment on the homeowners and pay you over time, maybe 5 or 10 years with interest." I discussed it with Patricia, and we countered with a structured settlement. The HOA would pay $2 million upfront through a special assessment and bank financing, then $400,000 per year for 10 years, with 5% interest. In exchange, I would grant them a permanent easement for the existing amenities. The total payment would come to $6.2 million, accounting for the interest, but it gave the HOA breathing room and allowed them to keep their community center and pool. The HOA membership voted to accept the settlement by a margin of 73%. It wasn't unanimous, and I knew some residents would always resent me, but it was done. The settlement agreement was signed in June 2026, and I received the first payment in July, but that wasn't the end of the story. Patricia had one more card to play. "Marcus, there's another aspect to this case we need to discuss," she said during a meeting in her office. "Your grandfather documented repeated objections, and the HOA deliberately ignored them. Some of the board members, particularly Brenda Morrison, knew they were trespassing and chose to continue anyway. That's not just a civil matter, it could be criminal fraud or theft. I hadn't considered that angle. You think they committed a crime, potentially. They knowingly used property they didn't own and collected fees from homeowners based on amenities they had no legal right to provide. I think we should refer this matter to the county attorney's office for investigation." Patricia prepared a detailed referral package, including all the evidence we had gathered. The surveys, my grandfather's letters, and the HOA's dismissive responses. The board meeting minutes where Brenda had suggested waiting out my grandfather, and the financial records showing how much money had been collected. She sent it to the Maricopa County Attorney's office with a cover letter explaining the situation. 3 weeks later, I received a call from an investigator named Detective Sarah Palmer. She wanted to interview me about the case. We met at a coffee shop near downtown Scottsdale, and I spent 2 hours walking her through everything that had happened. "This is a complex case," Detective Palmer admitted. "Property disputes usually stay in civil court. But there are some elements here that concern me, particularly the knowing and willful aspect. If board members knew they were operating on land they didn't own and deliberately avoided resolving the issue, that could constitute fraud or embezzlement under Arizona law. What happens next? I'll continue investigating. I'll need to interview the former board members, review all the documents your attorney provided, and consult with prosecutors. This could take months, but I'll keep you informed." The investigation proceeded slowly through the summer and fall. Detective Palmer was thorough, interviewing dozens of people and subpoenaing additional records. In November, she called to let me know they were moving forward with charges. "We're charging Brenda Morrison and 2 former board members, Gerald Spencer and Linda Tucker, with fraudulent schemes and artifices under Arizona Revised Statutes Section 132310. Essentially, they knowingly participated in a scheme to use property they knew they didn't own for financial benefit. The county attorney believes we have a strong case. The arrests happened quietly on a Tuesday morning. Brenda Morrison was taken into custody at her home, along with Gerald and Linda. All 3 were processed and released on bond within hours, but the news spread through Scottsdale like wildfire. The local newspaper ran a front-page story: "Former HOA leaders charged with fraud in property dispute." I gave a brief statement to the reporter, emphasizing that this wasn't about revenge but accountability. My grandfather tried for years to resolve this properly. He was ignored and dismissed. These charges reflect the fact that you can't just take what doesn't belong to you, no matter how long you get away with it. The criminal trial began in March 2027. I attended every day, sitting in the courtroom gallery as prosecutors laid out their case. They showed the jury the surveys proving ownership, my grandfather's letters documenting his objections, and most compellingly, the board meeting minutes where Brenda and the others had discussed ignoring his claims. The prosecution's theory was straightforward. The defendants had knowingly allowed the HOA to continue using my grandfather's land because acknowledging the boundary dispute would have required expensive remediation. They had gambled that my grandfather wouldn't sue and that the problem would eventually disappear. In the meantime, they had collected millions in dues from homeowners who believed the amenities were legally established. Brenda took the stand in her own defense, claiming she had genuinely believed the HOA's surveys were correct and that my grandfather was mistaken. But Patricia had done such thorough work during discovery that the prosecution had dozens of documents contradicting her testimony. They showed emails where Brenda had discussed the Donovan problem with other board members, always framing it as something to be managed rather than resolved. The most damaging evidence came from a 2001 email where Brenda had written to Gerald Spencer. Donovan sent another letter about the property line. At this point, I think we just keep doing what we're doing. He's not going to sue at his age, and if his kids inherit the property, they probably won't even know about this issue. Let's just ride it out. The jury deliberated for 6 hours before returning guilty verdicts on all counts for all 3 defendants. Brenda Morrison was sentenced to 3 years of probation, 500 hours of community service, and ordered to pay restitution to the HOA for the legal fees and settlement costs her actions had caused. Gerald and Linda received similar sentences. None of them would serve jail time, but they would carry felony convictions for the rest of their lives. As I left the courthouse that day, a reporter asked me how I felt about the outcome. "Justice isn't always about harsh punishment," I said. "It's about accountability and making things right." My grandfather deserved better than what he got from these people. This verdict says that you can't just ignore property rights because it's convenient, and you can't gamble with other people's land and money without consequences. The following weeks brought a strange sense of closure. The first payment from the HOA settlement had been deposited into my account, and the structured payments were on schedule. The new HOA board was professional and respectful, and several residents had even apologized for the hostile messages I'd received earlier. The community center now had a plaque by the entrance acknowledging that the facility was on land owned by the Donovan family and leased to the HOA through a permanent easement. I decided to stay in Scottsdale and in my grandfather's house. The property was beautiful, and despite everything that had happened, I felt connected to the land in a way I hadn't expected. I used part of the settlement money to renovate the house, updating the kitchen and bathrooms while preserving the character my grandfather had loved. I converted his workshop into a home office where I could work remotely for my software company. One afternoon in late spring, I was sitting on the back porch watching the sunset paint the desert sky in shades of orange and purple when my phone rang. It was Thomas Chen, the HOA president. "Marcus, I hope I'm not bothering you. I wanted to let you know that we're planning a community event next month, a picnic and pool party to kind of bring everyone together after all the drama. We'd love it if you'd come. I know you're not technically part of the HOA, but you're part of this community's history now, for better or worse." I smiled. "I'd like that, Thomas. Thank you. And Marcus, I've been doing some research into the HOA's early days, trying to understand how things went so wrong. I found something you might be interested in. There are photos in our archives from 1988 during the construction of the community center. Your grandfather is in one of them." "Really?" "Yeah. He's standing at the property line, and it looks like he's talking to the construction foreman, probably trying to explain the boundary issue. But what struck me was the look on his face. He wasn't angry. He just looked sad and disappointed, like he couldn't believe people would do this to him. I felt a lump form in my throat. That sounds like Grandpa. He was never one for confrontation. He just wanted people to do the right thing. Well, because of your persistence, the right thing finally got done. Your grandfather would be proud." After we hung up, I walked out into the yard, past the old fence line that everyone had assumed was the property boundary for so many years. The desert was quiet except for the sound of the evening breeze rustling through the sage brush. I thought about my grandfather standing in this same spot decades earlier, watching strangers build on his land and knowing he didn't have the resources to fight them. But he had fought in his own way. He had documented everything, objected consistently, and left a paper trail that eventually led to justice. He had played the long game, trusting that someday, someone would care enough to make things right. That someone turned out to be me, his grandson, who inherited not just his property but his stubbornness and his belief that right matters more than convenience. The HOA would be paying my family for years to come, not as a windfall but as compensation for decades of wrongful use. The criminals who had enabled and perpetuated the fraud had been held accountable. The community had learned a hard lesson about the importance of respecting property rights and addressing problems honestly rather than hoping they'll disappear. I attended the community picnic the following month. Some residents were friendly, others kept their distance, but overall the atmosphere was positive. Children played in the pool that sat on my land. Couples played tennis on courts that existed because of an easement I had granted. And families gathered in the community center that would have never been built if someone had checked the property lines properly in 1988. As I watched everyone enjoying themselves, I didn't feel angry or resentful. I felt satisfied. The wrong had been acknowledged, compensation had been paid, and justice had been served. My grandfather's voice had finally been heard, 37 years after he first raised it. Thomas found me by the pool and handed me a cold drink. "Thanks for coming, Marcus. It means a lot to a lot of people, even if they won't say it. Thanks for inviting me, and thanks for handling this the right way once you took over. I know it wasn't easy. The easy thing would have been to keep fighting you in court and hope we'd get lucky. The right thing was to acknowledge what happened and fix it. My parents taught me that admitting you're wrong is hard, but it's the only way to move forward." As the sun set over Meadowbrook Hills that evening, I realized that this whole experience had taught me something important about justice and community. Justice isn't just about winning or getting paid. It's about acknowledgment, accountability, and the belief that wrongs can eventually be made right, even if it takes decades. My grandfather had never stopped believing that, and neither would I. The land beneath the community center, the pool, and the tennis courts would always be Donovan land, and everyone who used those facilities would know it. The HOA had learned that you can't build a community on a foundation of ignored rights and convenient lies. And somewhere, I like to think, Grandpa Robert was watching with that gentle smile of his, satisfied that his grandson had finished what he started, and that justice, however delayed, had finally arrived at Meadowbrook Hills. The payments continued arriving like clockwork. Every year on July 15th, $400,000 was deposited into my account, a reminder that accountability sometimes moves slowly but inevitably. I invested the money wisely, set up a scholarship fund in my grandfather's name for local students studying surveying and property law, and donated to organizations that helped elderly people facing property disputes they couldn't afford to fight. 5 years after the settlement, Thomas called me again. "Marcus, I wanted you to hear this from me first. We've just finished paying off the special assessment early. The homeowners voted to use some reserve funds to accelerate the final payments. You'll be receiving the remaining balance next month." "That's great news, Thomas. I appreciate you letting me know. There's something else. The board wants to rename the community center the Robert Donovan Community Center, if you'd be okay with that. We want future generations to know what happened here and to remember that integrity matters more than convenience." I had to pause for a moment, overwhelmed by the gesture. "Yes, I think Grandpa would like that. Thank you." The dedication ceremony happened on a bright Saturday morning in October. They had commissioned a bronze plaque that told the whole story in unflinching detail. How the subdivision had been built on land it didn't own. How Robert Donovan had objected for years. How he had been ignored, and how justice had eventually prevailed. It ended with a quote from one of my grandfather's letters. "I believe in doing what's right, even when it's difficult, even when no one is watching, even when I won't live to see the result." Several of my relatives attended the ceremony, including my mother, who had tears streaming down her face as she read the plaque. "Your grandfather talked about this issue sometimes," she told me afterward. "He was so frustrated that no one would listen. He'd be amazed by what you accomplished." "I just finished what he started, Mom. He did all the hard work by documenting everything and never giving up. The years that followed were peaceful. I expanded my software company, hired a small team, and built a successful business while staying rooted in Scottsdale. The property my grandfather had left me became not just my home but my legacy. I eventually married a woman named Barbara Johnson, who worked as a teacher at the local elementary school. We had 2 kids, and I made sure they grew up knowing the story of their great-grandfather and the importance of standing up for what's right, even when it's difficult. The Meadowbrook Hills community thrived. The new leadership maintained the amenities beautifully, kept dues reasonable, and operated with a level of transparency that would have been unthinkable under Brenda Morrison's regime. The criminal convictions served as a stark reminder to HOA boards throughout Arizona about the importance of ethical governance. Brenda Morrison eventually moved away from Scottsdale, unable to escape the stigma of her conviction. I heard through the grapevine that she tried to get involved with another HOA in a different state, but was rejected once they discovered her background. Gerald and Linda largely disappeared from public life, their reputations permanently tarnished by their roles in the fraud. On the 10th anniversary of discovering the property boundary issue, I stood in my backyard looking out at the community center that bore my grandfather's name. The journey from that confused contractor showing up at my door to this moment had been long, stressful, and occasionally frightening. But it had also been necessary and ultimately rewarding. Justice had required patience, documentation, skilled legal representation, and a willingness to stand firm against pressure and hostility. But it had also required something else. The foundation my grandfather had laid through his persistent objections and meticulous record-keeping. Without his foresight, without his refusal to let the issue be forgotten, none of this would have been possible. As I watched kids playing in the pool and families gathering for a weekend barbecue, I understood that this outcome was bigger than just my family's rights or my financial compensation. It was about the principle that property rights matter, that communities must be built on truth rather than convenience, and that individuals can make a difference even against powerful institutions. The Meadowbrook Hills HOA had collected dues using my family's land for decades. A judge had made them pay it all to me. But more importantly, the system had proven that justice, however delayed, was still possible. Rights could be vindicated, wrongs could be corrected, and people who abused their authority could be held accountable. That was the real victory, worth more than any settlement check. And that was the legacy I would pass down to my children, along with the property and the story of their great-grandfather who never stopped fighting for what was right, even when everyone told him he was wrong. As the sun set over Scottsdale that evening, I raised a glass to Grandpa Robert wherever he was. We had finished what he started. Justice had been served. And the land he loved would remain in our family for generations to come, a testament to the power of persistence and the enduring importance of truth.